And we're going to elaborate on what that means, the capacity of police officer to assess a child's need for psychological care and ability to consent. The Child Diversion Committee, that is the governance structure, we do recognize gaps in it. So the Child Diversion Committee and issues related to the convening of such committees. Provisions for persons with disabilities in the Act. Specific stakeholder concerns. And that we will look at some specific areas. So for example, the meaning and intent of child diversion in the Act. So for example, formal adjudication not defined in the Act. That is very important. When does formal adjudication begin for the purposes of the application of child diversion under the Act? And so you will find that at page 8 of your document. That is our first sub-issue number 1. If you so desire, I can speak to it, but I'm just highlighting it. The need to ensure that diversion is prioritized by the courts, that's important as well. So the question as to whether there should be mandatory consideration for child diversion, barring exceptional circumstances. That you can find the detail of that on page 9. That's a sub-issue that is very important. There are certain discretions of the courts, and what we're saying is that there may need to be some consideration by the committee to allow for that mandatory referral to the child diversion program.
I think, colleagues, the issue there which we will eventually make a decision on, whether in fact, because it's a child and in the best interest of the child, we are trying to divert them away from the formal criminal justice system. So should it be mandatory from a child is 17 and under for the child diversion offenses that the judge consider that? And in other words, the judge should really, make it the first consideration. And if they're not going to refer the matter to child diversion, they give reasons why they don't think this is appropriate for child diversion. So in other words, what I think the committee is saying, should Parliament make it almost mandatory for child diversion offenses? Remember, and we can then have a look at what are child diversion offenses. There's many offenses that are not child diversion offenses, like murder, shooting, some with intent, robbery. These are not child diversion offenses. But to the extent you might have an assault occasioning actual bodily harm, that is a child diversion offense. Now, should it be mandatory that the judge say, you're 17 or you're 16, and I'm going to look and get a recommendation from the police or from the social inquiry report whether you should be referred to child diversion. Now, this is not necessarily what happens now as I understand it. The court literally, in some cases, not in all, but literally asks the child, did you do it? And if you did it, then you plead guilty. No, that is not the way it should be, because the idea is not to plead guilty and then you say you go for child diversion. The question is this an appropriate case for child diversion? And if it is, and the child goes through a process of child diversion and successfully complete, then the matter is literally dismissed. So the child doesn't have a record. But you will see that there's a section in particular where the judges interpret that taking responsibility means pleading guilty. And to our mind, that was never the intent of the act. Sorry, Mr. Member.
I'm agreeing with you, Mr. Chairman, but a part of the definition lapse, or there's a lacuna in the act, is the definition of court. There are judges currently who are thinking in relation to certain matters, whether it is the Supreme Court that has to make that decision. No, I'm just saying, with certain offenses, the parish court judge is saying, well, we have to leave that for the Supreme Court when they actually have the power. So the redefining what child diversion is, understanding that it is actually a process to steer minors away from the formal adjudication, being a judge should say, well, ought to say, you know, I'm so sorry that I have to take you through the formal system. And so we're not seeing, when it comes to definition-wise, defining court clearly, as in which court is able to do that.
No, and that's a good point, Member Buchanan, and colleagues, that's something we should address. In other words, once it comes before the court, and it is a child, that court should be empowered to say.
And so when there's an issue, because I know, especially within the Constitution, the doctrine of separations of powers is not clearly there, but the doctrine itself is not a physical.
No, but
but what I'm saying, the point I'm trying to make, Chairman, is that when it comes to the taking away power from the court, as in when Parliament is assumed to be tying the hands of judges, judges can sometimes. No. I'm saying I just want to complete the thought that what we're saying, that the mandatory consideration is what is of importance, to say that this is the first step, because the child diversion becomes moot if there is no consideration at the beginning of the process.
So I'm agreeing with you.
Right.
In that, what we're saying is that the court, from the fact that you're dealing with a child, you look at whether child diversion is an appropriate process. The court may well say, having considered it, we don't think this is one appropriate for child diversion. You're with me?
I'm with you, but I'm wondering if we can take it one step higher by not necessarily having a physical space, but appreciating that the treatment of minors, the 17, the 12
under
to 17 under 17, but criminal responsibility starting at 12, to say that they are directed to a particular court that makes that determination, i.e., once the court identifies a child as being 12 to 17, then you treat them in a particular way. The act empowers the court.
You're saying that most of these should go to, say, the family court.
Family court is the correct space, and it is at that time where you send them to child diversion, and many other things would have to be tweaked, but certainly to say that juveniles generally are treated as children.
A matter for consideration.
Yes. Thank you, Chair.
Any other comments? Otherwise, go ahead now.
Okay. Yes. The next slide.
So on page 9, number 2, what we just dealt with was the prioritization. Okay, good. Go ahead.
Requirement for guilty plea. Under Section 33, Sub 2 of the Act, there is, the Chair would have also alluded to it earlier on in his speech, this requirement for a guilty plea for warning could be construed as a form of compulsion. And so we would welcome the committee's review of such a provision to make the appropriate recommendation. You can find that at pages in more detail, 11 to 12 of our submission document, that is sub-issue number 3.
And if I might help, if you don't mind, colleagues, they have set it out very nicely on page 11. In following the Convention on the Rights of a Child, to which Jamaica is a party, the Convention literally urged member states not to pursue guilty pleas. So, in fact, if you read, if you see at the bottom of page 11, where Article 42B says that a child is not to be compelled to give testimony or to confess to guilt. You see, but the way the Act 33(2) has been interpreted by some courts is that to move to child diversion And in accepting responsibility, and it speaks about accepting responsibility. And I've heard a judge, and at the meeting says that is the basis on which he refers a child to child diversion after the child accepts responsibility and pleads guilty. And we had a good argument with her to show that was not the intention of the act. I mean, the children's advocate and myself had to show her a different section 40, forget the section now, where accepting responsibility doesn't mean pleading guilty. Because if you plead guilty, then you get a record, or at least it is there that you were convicted if you plead guilty. So the idea now, we want to look at this particular section to make it very clear that accepting responsibility doesn't mean pleading guilty. But it's important for the child to go on child diversion referral, that they accept that they were responsible or they're party to the offense. Okay? Sorry, Julia, go ahead.
And as we move along, again, in terms of that ambiguity, clarity, and to be more concise, we also saw that there was a need to look at adjourning a matter sine die under Section 33, subsection 1 of the Act, which effectively suspends a matter indefinitely without assigning a date for a further hearing. And my colleague, Mr. Levy Rodney, the child diversion officer, will share with you the impact of such a situation on children, especially after they come out of the program and they have moved into adulthood, and if they're looking at job, the implication when the situations are there, it carries forward. So we lose the effect of what we desire. So you will hear from Mr. Levy.
You have a case study on that, Mr. Levy. Go ahead.
Mr. Levy.
Yes. Good afternoon, committee members. Mr. Chairman, permit me to begin with a story. Not a story from poverty or neglect, but a story of an affluent young boy whose mother struggled with his behavior from an early age. Despite providing a stable and comfortable home, she faced ongoing challenges, defiance, anger, and emotional outbursts that worsened over time. Like many parents, Mr. Chairman, she hoped he would grow out of it. Instead, the problem escalated. One evening, in a fit of rage, the young man destroyed his mother's computer. Overwhelmed and unsure what else to do, she reported the matter to the police. He was subsequently charged for malicious destruction of property and placed before the court. Mr. Chairman, this is how easily any child, regardless of background or social environment, can enter the justice system. Fortunately for this child, the court referred him to the child diversion program. Through the program, he received counseling to address anger management and participated in family therapy that helped rebuild communication and trust between mother and son. Well, I say the family and the child. He was mentored, guided, and held accountable in a structured but supportive environment. He successfully completed the program. 1 month later, his mother returned with tears in her eyes. And not to complain, not with another child for referral, but to express gratitude. She simply said to the child diversion officer, "Thanks for giving me back my son."
Members, can you imagine? These are umpteen cases. Go ahead.
Mr. Chairman, That is a true impact of child diversion. The child diversion program serves children and families from all socio-economic backgrounds. It recognizes that behavioral challenges and emotional struggles do not discriminate by class or community. Through timely intervention, children are connected to counseling, emotional support, mentorship, and other essential services. Families also receive support that strengthens relationship and improves parenting capacity. The impact on the nation is significant, Mr. Chair. Child diversion addresses the root cause of behavior before they escalate. It eases the burden on the court and correctional system by keeping children out of formal incarceration pathways. Most importantly, it strengthens family and safeguards the future of our young people. When we invest in child diversion, we invest in prevention, we invest in restoration, we invest in national development. Each child redirected represents a life reclaimed and a family restored. The program demonstrates that accountability and compassion can work together and transform life. Mr. Chairman, when a parent can say, "Thanks for giving me back my son," it reminds us that justice is not only about punishment, it is about rehabilitation, it is about restoration and hope for the future of Jamaica.
Okay, the matter was before the court, and the court sent that child to child diversion. What did they go back to the court now? What happened when they went back to the court?
They went back to the court for the court to take it off their list. So in essence, when the child finished the program, we sent back a report to the court to inform the court that the child has successfully completed the program. And hence, it would have come to an end at that point.
So the child did not have a conviction?
No.
Okay, sorry, Venetia, go.
The matter that you're referring to was, we had a case recently where a child completed the program successfully and became an adult and was working. I think he worked for about a month or two, and he was told that there were adverse findings on his record. As such, he was relieved of his job.
He was, what?
He was dismissed from his job.
And this is, but the child, that adverse was from the referral of the child diversion.
Yes, the matter was referred to us, but
you see, that
and he successfully completed the program, however.
But what happened in the court, because that is something that we have to address, is it that the court dismissed the charge, or there was a guilty plea? What took place in the court? Do you know?
I will ask the officer to confirm, because
And let us know, because you see, this is the sort of thing that if it is not dealt with appropriately, then it could have, as you pointed out, adverse effect. You know. Well, this is why I wanted to find out. Yeah, so,
No,
sorry.
I don't understand.
You want to defer to Ms. Cuthbert, or you want to go?
No, I'll defer.
Thank you, Chairman. No, I was just wondering if it's the fact that the child had to plead guilty.
Well, this
in
is
that
the point.
instance, why? And so this is what we're trying to, this is the mystery
figure
we're
out.
trying to get rid of, right? So this would not happen once we pass this particular bill.
And adjust it.
And make this adjustment. So this will not be where the child pleads guilty in court and then coming back where it shows up on their record.
So Ms. Clark, could you get that information? Why did he lose his job because of an adverse finding when he has completed the program successfully? So, you know, something went amiss there. Okay. Yes, Mr. Levy. One second. Yes, Mr.
Yeah,
Levy.
I just wanted some further clarity because there's an obligation to secrecy under, currently under the Act, which is 39, and unless it was possibly the young man was trying to go into military or something like that, juvenile convictions are generally not. It doesn't follow you, even if it's or ought not to follow you clearly. And two, the Act currently as drafted, excellent section, Part 3 General, where it speaks of obligation to secrecy. So when you say adverse findings,
yes,
that's
I'm
not
surprised with that.
That's not conviction. That is somebody giving information possibly to a person who it wasn't pursuant to a court order or any person which is permitted or required by law, which is not in these circumstances an employer outside of government.
All right, thanks, Member Buchanan. You have something further than that?
Yes, thank you, Chair. Just to make a clarification, is that the example that is being discussed with the person, adverse finding came out in his background, is separate and apart from the illustration I gave. Right, but what happened in that case, well, from our understanding is that once the child has completed the program successfully, there should be no adverse findings on the child. However, for whatever reason, when the background check was done, I don't know at what stage the child started working. Well, we have other cases, and Ms. Case will be doing that, but this particular one, he started working at a call center, and he just got a message from his boss to come to his office, and they told him that he can't continue working in the call center because based on the background check, there are some adverse findings, and he has to.
Well, these are the matters which we need to address, okay? All right. No, this idea of the adverse finding, when they have successfully completed the program, should be looked at, okay? Go ahead, Julia, turn on your mic.
On the matter of definition for the child diversion program itself, so we need to make a distinction as to what is the child diversion program vis-a-vis the national child diversion program, and there is no provision except Section 2.1 of the Act, where it says a child diversion program means a program developed under this Act in which a child in conflict with the law is required to participate. But we need to make distinctions in terms of the program itself. What does it mean, and not just this umbrella statement. So distinction between child diversion program vis-a-vis an individual child diversion plan once they enter into the program, and they are identified with unique treatment plans and so forth. So you can look at page 13 where we would have elaborated on that as an issue, page 13, 1-3. Another matter is whether a child's participation in a child diversion program always necessitates a child's consent. This is in the context of the phrase required to participate. And so there's that language in the Act that says that the child is required to participate in the child diversion program, vis-a-vis what we understand consent to be. And so is a child diversion program definition and the requirements for the child's consent under Section 9.2, sub-issue 2. You can look at it at pages 14 to 15. That is another issue area that we want to elucidate on by the committee. Whether child diversion applies to children convicted, sentenced, paroled. Key definitions in the Act: the child diversion, child diversion program, child in conflict with the law, it excludes reference to child offender. And if you look to pages 15 to 18, we would have set out the context and made certain recommendations as well.
Well, you want to indicate, for instance, look at the recommendation on page 15. You want to indicate what those recommendations are.
Okay. So at page 15, we would have indicated I'm duly advised. Thank you. Recommendations at page 18. To reconcile these apparent contradictions, it is important to consider the policy position and the legislative intent. While it is evident that the Act aims to uphold a policy position promoting diversion and rehabilitation at various stages, the process is muddled. If the intent of the legislation was to ensure the children who've previously faced adjudication, convicted or sentenced, are not to be excluded from consideration for diversion under the Act, it then becomes evident that the definitions of child diversion, and in conflict with the law may require amendment to harmonize with this broader intent. The second point, Section 44 of the Act serves as a transitional provision, indicating that the provisions apply to any child offender, young offender, and parolee who is a child at the time of conviction or sentencing, effectively applying the Act retroactively. However, given the Act was enacted in 2018, this raises a critical concern regarding the absence of a cutoff age in the Act. Generally, and for the purposes of this provision, if a person was convicted as a child in the past, in some instance, they may now be well into adulthood, potentially rendering the applicability or suitability of the child diversion questionable. To enhance the legal soundness of this provision, it is essential that the Act establishes a definitive cutoff age. And so one of the suggestions that the program has and recommended that we need to look at to include in the legislation that up to age 21, so we have a period of 3 years, say 17, that they would have come into the child diversion program, and up to a maximum of 21 to continue. What we find is that if we have it over 4 years or so, they came into the program at 17, but they're now 22. We find it challenging to engage with them because they're not resistant, they're not adults, and they're not minded to be guided or to be treated under the program. And so that is just one example, but there are different situations under this section that we're asking for some clarity and directions.
There's also on page 15, colleagues, two recommendations which will be useful for us to examine and discuss at another time. In section 33, it has a phrase in the third schedule also that refers required to participate. So the recommendations are the current reference in the definition to required to participate should be refined to clearly reflect the context in which a child's participation in a child diversion program may be voluntarily as against mandated. And also specify the consent timing where there's distinction to be made between voluntary consent to participate in a child diversion program and mandated participation. Consideration should be given to clarifying the provisions in respect of consent timing, whether the child consent being a prerequisite for participation in a diversion program prior to any formal court involvement. That's a pre-charge stage.
15.
Page
15.
All right, no problem. Just a second. Yes, go ahead.
Something I'm finding troubling is asking children to consent especially we're using consent as opposed to willingly participate, which is completely different in terms of wording. I can't think of a situation where you can require a child who we're saying going back to the sexual offenses, you're a person underage, sexual offenses because they cannot consent to participate in the activity, to bring them before the court and invite them to consent. It's almost, it's problematic, and even by language.
That is why we want to look at it
we wanted, I'm with that, but yes. I don't want to leave the... Yeah, it's absurd. It's almost, legal absurdity. Thank you, Mr. Dalrymple. But I don't want to skip over the section 44, because I'm thinking if it is that, if the act is updated to clearly define a child being at the date of the commission of the offense. So if you're 17 when you commit the offense, there's some child diversion that's taking place regardless of the delays within the court. So you find yourself 18, 3 years later, having committed the offense, and child diversion ought to apply to you. I think, though, where it says the child offender was brought before a court or the young inmate was sentenced or a grant of parole, it's not impossible for a child to be 15 and completes his sentence and is still a child, and therefore child diversion applies. I think we need to fix our mind as to when a person become adult, processes of rehabilitation, which is my friend's area, post leaving the DCS, as well as just the formal processes as an adult in terms of transition would not be the remit of child diversion. So that possibly is something to consider, except in the space of defining the definitive date of saying at the age of 17, having committed the crime, child diversion applies to you.
And they're asking us to fix it.
Well, okay, very well. Got you.
So make a note of it.
I have it, but I'm just raising it here for the purpose of the public, so that they don't think.
Because they're agreeing with you that something needs to be fixed right there.
Okay.
Go ahead. Turn on your mic.
So requirements and procedures for referral to the child diversion program. Guidance required for section 9(2) as to what constitutes consent. We want to look at acceptance of responsibility without having been unduly influenced by another person. How these matters are navigated by the court and the police is very crucial, and we do have variation of this. Some judges being of the opinion that acceptance of responsibility means entering a plea of guilt. And so if you continue on pages 18 to 19, would have provided further details on the situation. Whether there is a conflict between section 9(2) and section 2(3)(b) of the Act, section 9(2) has 4 requirements for a child to be considered for referral and uses the term may be considered versus section 2(3)(b) that says shall be considered for admission, seemingly mandating the child's consideration for referral on one condition: the child accepts responsibility. And you can go to page 20, where the details are provided. Consent in writing, section 9(2). No requirement in the Act, there is no requirement in the Act for the child's consent in writing, it is silent, to participate in the child diversion program. And still on page 20, you will see the details on that and why it is of concern to the program. Page 20. So it's sub-issue number 2, page 20.
Yeah, sorry, go ahead.
I'm just wondering. The issue of consent to the program or to the child's participation is precisely, in my view, why there's a requirement for a guilty plea to be entered. Because although it flies in the face and it is, in my view, an anomaly where you're trying to avoid previous adjudication, you're trying to avoid adjudication, formal adjudication, but you're requiring a guilty plea, which requires adjudication. Because for you to enter a guilty plea, it means the adjudication process has been triggered. So, where you have pleaded guilty, and it is for the judge now to order or to determine whether you are referred as a prerequisite to child diversion, does the judge require your consent?
Well, this is where we need to make it very clear.
In other words, do you require consent for me to sentence you?
No, that's
you can't even. So,
no,
so there is that.
No, and remember,
conflict.
Williams, that has been a lacuna or ambiguity in the law. And
so I think once we address,
it has caused some problems.
So once we address that underlying foundational issue of the plea, and its requirement for a guilty plea, I think it will solve a lot of problems.
And that's the idea which...
Yeah, and consent.
And that is both matters need to be addressed. So we will find a way to adjust the law so that it becomes clear that a guilty plea is not required and that consent is really also not required. You understand? The reason, what I think is required would be the taking responsibility that you are involved in the act. Because if you say you never do it, then I don't see what you're going to go on. So, but it is a matter for us to further discuss. All right?
His mic.
Council has had that experience, but I've had experience.
No, one at a time.
Oh, sorry. Yes, I've had experience practicing in the court where offenses which require and fall within the purview of child diversion were dealt with by the court without guilty pleas. The judge, the prosecutor and I had discussions, and the prosecutor reasonably looked at the case, pardon me?
No, in fact...
Yeah, reasonably looked at the matter and said, hey.
But this happens...
And the judge, without any plea or anything, the matter was referred.
But this happens a lot, because if it's the police that refers it, then there's no guilty plea at all.
No, I do understand where you're going.
So bear in mind, remember a fair percentage of the cases are referred from the police. And we'll be looking at other possibilities where the referrals could come other than from the police, okay? But that will be later on. Member Dalrymple, you wanted to... Okay, go ahead, continue.
On the same point, I would like to, if you will permit, Chair, for our colleague, Ms. Sandy Lou Cole-Jarrett, to share the Antiguan model, which provides a really nicer option, for want of a better word, but she will.
Good afternoon, members. So just to clarify two things. So in the Act, there's a provision.
They call it the Child Justice Act.
Yes, Minister, that's correct. So in the Act, there's one section specifically that says that the child is required to enter a guilty plea. And that's under Section 33, where the judge can issue a warning. Other than that, in the Act generally, the provisions speak to the child acknowledging responsibility, the child giving consent. So those are the two main things. The challenge is that some judges, so the challenge is that some judges don't interpret the acceptance of responsibility in the same way. So outside of the Section 33, they generally think that accepting responsibility means that they have to ask the child to plea. So that's one. The two, our Act does not define or give any guidance as to how the child's consent is obtained, how the child acknowledges responsibility. So they're just operating on what they think is correct. So there's no guidance there. But when you look at the Antiguan model, and internationally generally, because child diversion is based on consent and acknowledging some type of responsibility, other models define it. so as to not cause confusion. So the Antiguan model says acceptance of responsibility means admission of responsibility for an offense by a child without the formal admission of guilt. So our act is not specific in that way. So that is the distinction that I wanted to make. Yes. Yes, so it gives some level of clarity, and further direction can be provided in the act as to how you
I think you dealt with this in the, what page is it?
The
page. I think I read it somewhere. You dealt with it.
It's there. I can't recall the specific section or the page number at this time, but when you get an opportunity to go through, you will see the issue being fleshed out a little more. Yes, thank you.
But both Antigua and Fiji, and I hear Kenya now, are looking at our act and refining it. Right.
We're gonna
Julia, you had the page where that was dealt with the Antigua Act?
We were looking at the Fiji model. I was saying page 25 for that one, but not the Antigua one. We will find it shortly.
So the Antigua one is not mentioned in here.
Oh. But the Fiji one did? Okay. Sorry, remember.
Madam, I appreciate your explanation, and I think that's where the legislation needs to go. But even as you were making the distinctions, you see the discomfort with the word consent. I think one of the strongest things that we can look at in terms of child diversion and a workable thing is similar to restorative justice. The judges say, take it outside to restorative justice, and then you're cloaked in the type of privacy where a judge need not look at anything else, where that child would be able to say, I did this, I didn't mean to do it, and the punitive nature of the justice system is not hanging over their head in that environment, which is why the diversion process is important. So the act saying you can, the acceptance of responsibility and all of that has to be outside of before the court, which is dealing with children, is an in-camera process. So I'm envisioning courtroom 2 in St. Andrew, halfway through court, and you have a child is there, and it's like a public kind of thing. So the court as defined, family court, the privacy of it, and the diversion aspect is important.
And I think in future, Member Buchanan, if these matters are not dealt with in family court, then once a child, the court should sit as a children's court or a family court, so that these matters are not publicly dealt with. So in other words, you can say if there are a number of matters where children are coming before the court, then the court for a half an hour or for an hour, clear the court and just sit as a family. It does happen,
I was going to say, if I'm allowed to say that, I don't want to be accused of sending out misinformation, but the court, in its wisdom, always clears the court, but is the form of convenience or the forum of convenience that I'm making reference to, that you appreciate that you're not in speaking to the child and not in big court, so I'm in big trouble. And it puts me in a situation where I'm not going to accept responsibility. I am afraid of being, the punitive nature of big court. So they must appreciate where they're at and what the law of the land is doing to protect them from going down a slippery slope.
Right.
Thank you.
Right. Thank you, Member Buchanan.
Just for corrections, it is page 35, and even though that section does not go into detail as per Mrs. Cole-Jarrett, but we identify the act for Antigua, and then we also cited the Fiji. So at your convenience, you could also look at those enactments as guidance.
Sorry, go ahead, Member Gould.
Mr. Chairman, thank you very much. I have to tell you, I'm quite excited to participate in this committee, and in particular to hear the contributions from my colleague, Member Buchanan, because he seems to have quite a bit of thought on this matter. I wonder, though, if you'd permit me to say a little congratulatory note to the division, to the ministry, because I have for long been asking for entities to come with their position to guide us, to help us to understand where you see problems before we embark on hearing submissions. And I think this is one of the few times that I'm seeing such a comprehensive document that has clearly been well thought out and well deliberated on.
I want to thank you on their behalf, because, I took the opportunity to read it.
Yes.
And it's a good document.
Yes.
And I'm going to beg colleagues, I know you didn't have the opportunity, but to read it and at another time.
Well, we'll have to read it, Chairman, because it is really what will kind of focus our attention, apart from our own experiences, like Members Williams and Buchanan may have had in the courts. But what I wanted to just get some clarity on, once we have gone through and taken a look at some of the issues identified and recommendations made, prior to our own deliberation on those matters, we will immediately begin to hear submissions. Because what I think we're one moment, please. A part of what I think we're doing. So you indicate an issue, and it gets us thinking, and the minds are bubbling over here. So we're kind of, interrupting you with questions and concerns. And I wondered what's next after this, so that just that we could have.
Sure. But what was a little concerning before I started is that I understand you all never got the document.
No, we didn't.
You see, and that was what was disturbing, because I thought you, Anyway, the point about it, though, is that virtually all of these members will be available. Everybody will be available for the next, until we finish and deliberate. They will be here for the deliberation, for further clarification if needed. And and they will have to address the final report too, okay? So that, after Ms. Bigon has finished presentation, that doesn't mean it's the end. We will still make the team available for questions that we may have after we fully digest the document. All right?
Very well. Thank you.
So we're going to ask her to wrap up, and because we have a few members, the child diversion officers, who want to give us some examples of their encounters on the program, okay? Which would take us to the end. Go ahead.
As we wrap up, there are three things that you will permit me, Chair. But firstly, I would like to express our appreciation on you recognizing the quality of the documentation that we have worked to provide to you. And I want to particularly recognize that I am not the author of that document. My colleague here, the senior policy analyst, is the person who crafted this documentation, and we just want to recognize that. So, Chair has asked us to wrap up. I'm going to go to all the issues in this summary PowerPoint presentation. It's detailed in the document, but we particularly want to make a statement from the Social Justice Division as we speak to, because we're going to one aspect of it. We're not only going to be looking at the expansion of referral points and other issues, but we're also going to look at the option of decriminalizing sexual offenses and as it relates to children under the child diversion. But we just want to provide a holistic perspective that we'd like you to bear in mind as we do that contemplation, and we also highlight the decision of the 2016 select committee that the chair would have mentioned earlier on. So I'll just get to there.
Sir, you had a concern.
Chair, while that's happening, can I just ask, would it be possible for the committee clerk to provide us with a copy of that 2016 report?
It is available. And you have a week. And indeed, I mean,
we can provide it to
the member next door to you can bring you up to date where we are.
But we can provide it to Mr.
Because from October, we have been trying to see if we can get that legislation before Parliament.
Not so much, not the legislation.
The
Chair,
report itself.
The report of the select committee.
Yes.
The 26th
We'll get a copy to the clerk, and especially that recommendation for him to just highlight it, because that report came out in around 2017, 2018, and they have been working on the legislation since then. So we need to just sort it out. Sorry.
If you permit, Minister Chair, we do have a soft copy that we can provide to Mr. Nash for circulation. So we would have been speaking and identifying individual technical issue areas that we want to have amended or expand or include in the Act. We just want to give a social justice perspective, because one of those or two of those areas, the issue of the closing age of sexual offenses activities. So the social justice perspective on it is, and I will read sexual offenses.
Refer to the page.
It is at page 40. Let me put on my glasses. 42. Page 42. Yes. So sexual offenses involving minors accounts for a significant number of the cases that are referred to the Child Diversion Program. According to statistics obtained from the Statistical Unit Institute of Jamaica, between 2018 and 2022, approximately 3,411 cases of sexual intercourse with persons under the age of 16 were recorded. The Sexual Offences Act, Section 10, speaks of sexual intercourse with persons under 16, is noted amongst the offenses listed in the first schedule of the Child Diversion Act. As such, when these cases appear before the courts, an opportunity is presented for the matter to be referred to the Child Diversion Program. A discourse around the potential of decriminalizing sexual offenses involving minors has been proffered, and credibly so. However, it is important to recognize that the Child Diversion Program is rooted in statute and addresses offenses that are classified as divertible. Essentially, the offenses falls within the legal framework of the Act and permits diversion as a response to a child being in conflict with the law. Child diversion via the Child Diversion Act relies on the existence of a potential legal charge as a trigger for referral. Therefore, how to maintain the child diversion pathway for a formal response where such offenses are no longer recognized within the context of a child being in conflict with the law merits further consideration. So let me emphasize. Therefore, how to maintain the child diversion pathway. So we're contemplating decriminalization, but it's very important that we still recognize the value of putting a child before the Child Diversion Program to rehabilitate and re-engage them and build a social awareness and understanding.
One of the things, colleagues, which we will have to consider, as Ms. Wigan has indicated, there's a likelihood that we could decriminalize the closing age sexual consensual activity. But that would take it out of child diversion, and the feeling is that many of these cases are deserving of referral to child diversion because a fair amount of mentoring, counseling take place, and the families in particular want that to happen because they're the ones who refer the children to the child diversion through the police or the courts. We're looking at, even if that happens, we consider that child diversion should not only be where you're in conflict with the law, but it should also have some diversionary offense, which are not necessarily in conflict with the law. In other words, where you have a certain level of delinquency, deviance, so it becomes preventative rather than reactive to an offense being committed. So one of the things I've been in discussion with the team is we are going to put it to the committee that referrals should be able to come from, say, the guidance counselors. And the guidance counselors could well refer to the headmaster or headmistress or the superintendent of police in the parish, and either the headmaster, headmistress, or the superintendent of police or a senior officer refer the matter to the child diversion officer, the conduct of the child. And the conduct doesn't have to be a breach of the law, but a number of matters are now referred to my colleague, Minister Dixon, right. So a number of matters are now referred to CPSA, what's the name of that committee again? CPFSA, that deal with misbehavior of children. Now, there's no doubt that they're also overwhelmed, but a number of the matters that come to them could easily be dealt with on the child diversion. And the reason why I'm saying so, they're going to be coming before us, is that the success of the program of child diversion is because of the mentoring and the psychological support that we give to children. And we're looking at how we can take some of that and prevent these children actually committing an offense. Sorry, Minister Dixon.
Thank you very much, Chair. This is something that we've been discussing at the CPFSA level, and we had a meeting earlier today because we've been looking at Section 24 of CCPA and how we affect the changes therein. And when I hear your team speaking on child diversion, I'm very impressed with what you've been able to do. And at some point, we need to not trip over ourselves.
Quite.
So we are supposed to be doing therapeutic centers, and we're supposed to also be doing, these are supposed to be residential plus places of safety where we're going to be doing child diversion type activities. We don't have enough resources as a government, so we're going to have to see how we coordinate better in that respect. And I see a lot of things that you're doing already that do not need to be replicated in CPFSA.
And may I say
so
this?
As a part of the process, I'd love us to work through that.
May I say this, Minister Dixon, colleagues? One of the greatest problems of most societies is that when children get into trouble, they're put into institution. And once they're put into institution, it's downhill. It is downhill. You understand? So if you, and I've done a lot of research on this, if you look at the people who become recidivists in the prisons, they're people who started out early in institution. They have developed the institutional habit. And therefore, what is happening in CPFSA need to stop. We need to stop institutionalizing our children. And that is why child diversion, we take them one at a time and mentor them in their homes. But once they go to an institution, believe me, Minister Dixie, it's downhill. Downhill after that. Member, sorry, go ahead. Wait 1 second, Ms. Cuthbert, then you.
If I may just add to that, as you know, where I sit, I am really happy for this conversation because I know that the therapeutic center was open a few years ago, but I'm not really sure how that is really impacting what we are calling now the uncontrollable children. And I, for one, also do not believe that children who are deemed uncontrollable, whatever that is, that they should be placed in the same institution where persons are there who have committed crimes. I really believe that, restorative justice or child diversion. Mentoring yes. is the way to go. Another thing, as you know, the government now, we've added peace to the Ministry of National Security. It's now Ministry of National Security and Peace. And if it is that we are looking at a more peaceful society, I think we have to make sure that we're instituting more of this, the child diversion, the gentleman, I can't remember, you gave a
Mr. Levy.
Right. You gave a perfect example of what child diversion can actually do for not just the child, but also for the parent. And so when you look at some persons, when you look at the Jamaican culture and the Jamaican society, a lot of us have gone through trauma. We do not know how to handle our anger. We don't even know why we're so angry. And I think a lot of these children, they are in that same predicament. Something might be going on with that child that he or she does not understand. And the parent themselves don't understand because they're just not exposed as to the why. And so we get this, ongoing trauma after trauma happening in our society, in our communities. And as you said, they came from possibly an affluent community. However, they still did not know why until an intervention happened where they were able to be counseled and mentored to say, and the child possibly now understood why they were acting out. So again, I welcome this child diversion, and I really want those children to be out of these institutions.
Should never be there.
And should never be there.
Yeah.
Never be there.
Minister
and so I
Dalry
can't
and
wait
then
for this
Buchanan.
to actually happen.
Minister Dalry.
I just want to congratulate again and emphasize. I grew up in a home where my mother was a children's officer until she died at 95. I still have practical experience of the children's home, and we should definitely stop institutionalizing. And I would say, Minister Dixon, any money that government is putting in those homes, I can say from exposure to what I have seen the child diversion unit doing in my short space of time, should be diverted to them, because every cent has been well spent.
You're recommending more money to child diversion.
Hold on. I am telling you, and I still, as an adult, interact with children's homes in Trelawney, and they are destroying rather than helping the children. Recently, just not even a month ago, a child that was a Brazilian child came here and was held in the home, and a judge, a judge referred that child to be incarcerated. She came here with adult family. And when they were leaving Jamaica, this is not a month old, leaving Jamaica, they went to the airport. They were then going to Canada, and the airport authorities recognized that the Canadian passport that the adults that she was with were fraudulently obtained. So they sorted it out. But the courts put the child, the judge incarcerated the child. She spent a week in an adult correctional center, and then they put her in a children's home. And she had an adult, and for the period 3 weeks that she was in that home, the authorities in the home refused to even let the Brazilian consular speak with her. And although reports came and her father came from Brazil to get her, they kept her there. And the whole child's life was just sting. The institutions that we have with our children and that we are spending money to pay staff to do are better, I am convinced would be better served in helping a child diversion program and giving the children a chance to rehabilitate and become a part of society.
Okay.
I really want to
Thank you, Minister Dalry. Yes, Member Buchanan.
Chairman, I'm here to split justice. I don't know if you had my friend, State Minister Dalrymple, make a pitch for all the money to go to your ministry. but I will say this though.
Ministry of Education going to give us some.
I will say this though. For my friends, I did get the pleasure of reading your paper from last week. So if I sounding bright, it's because I had a platform which was led by you, and I congratulate you and appreciate you for that. I did say last week about Section 34, and all my colleagues are painstakingly saying they have a problem with it.
Yes.
It is about the uncontrollable minor.
Yeah.
I take State Minister Dalrymple's point that it is a process that we have to eliminate through legislation. Court orders ought to be for diversion and even placement. As a priority. Placement. And I don't know if I could ever coin the term uncontrollable parent, but so oftentimes it is an uncontrollable minor is an indication of that.
What we're going to do, Minister Buchanan, Samantha Eaton, who is from the
she's here.
office,
Okay.
we're going to ask her to bear in mind some of these discussions,
right?
So that when we come to finally make decisions, she can guide us along. Okay, Samantha? And please have a look at the Fiji and Antigua Act, and there might be others, okay?
But just to say finally that Section 34, we collectively, even when you leave here, how to separate the uncontrollable minor in relation to even what court orders do when they interface in terms of sending them to homes is a last resort in light of what child diversion represents now and how we can strengthen that. Thank you.
Wonderful. You finished? You're going to let the officers...
The child diversion via the Child Diversion Act relies on the existence of a potential legal charge as a trigger of referral. Therefore, how to maintain the child diversion pathway for formal response where such offenses are no longer recognized within the context of a child being in conflict with the law merits further consideration. I would have made that point. The argument for decriminalizing sexual activity between minors may be driven by intention to remove the stigma and prevent criminalization of an activity seemingly prevalent among children, but it is crucial to also recognize that removing the legal penalties associated with such actions may not effectively address the underlying issues. So in fact, the decriminalization doesn't resolve the socialization, lack of education, or inadequate education around consent and relationship. Okay. So we're of the view
and that is at the end on page 43.
Yes, that's
okay,
correct.
No
so you will find the detail on it at page 42 to the end. And we recognize the supporting document that the committee, this House would have looked at in December of 2016, where it noted that a lengthy discussion by the committee, it made a certain recommendation about closing age group provision to prevent children within a certain age band from being criminalized in circumstances where they willingly engage in sexual activity with each other.
Okay, thanks.
The details of that, we will provide the documentation to Mr. Nash for circulation so you can be fully briefed.
Thanks, Julia. Yes,
Chairman, this particular concern, can I ask the team, have you had an opportunity to look at the legislative history, the process that took place when the Sexual Offences Act was first enacted in relation to this Section 10 provision? You haven't?
We have not gone through as far back as that, but we are more than and do intend to do so, so that we can better inform the committee as we meet on
I really would appreciate if you would do some a focused look at that.
Yes.
I happen to have been very involved in that bill when it first came to the Parliament, and I have repeated this on many occasions, that the intent of the then legislators was never to criminalize for quote-unquote consensual sex between minors. It in fact was not a part of the contemplation at the time. It somehow ended up being drafted in a way that caused it to be interpreted in that way, and I agree that it does. But we have carried on for some time. We've sort of dragged this error into the 2026. This was 2008 when I participated.
And I'm really hoping, member, that in 2026 we can address it.
Yes, it's a lot, and in fact, I mean, it came to our attention sometime in the 20-teens, I believe.
Yes.
So
Yes, 26.
I'm going to ask the team, for the benefit of those who keep repeating the narrative of the need for this, because it was first put in 2008, if they could just take a look at that, and I'm happy to have backdoor conversations with you about my experience and what we had been trying to do at the time.
We will most
Thank
certainly.
Thank you, Member Gould.
Thank you.
Now, a number of persons.
So at this point, we would like to invite, for you to hear, you'd have heard from Mr. Rodney, our parish
You decide to say who is going to.
diversion officer. We would like to invite our Director for Child Diversion, Ms. Vanessa Clark, to give a synopsis on the program and what we're practically working with, and then Ms. Tiffany Case will share one or two testimonies on the success and the gaps that would have recognized.
Thank you again, Mr. Chair, and good afternoon again, everyone. So because you already have an appreciation of what child diversion is in terms of the definition, you know, we focus on children between the ages of 12 and 17 who come into conflict with the law, and we want to ensure that they achieve their full potential as functional Jamaican citizens. In order for us to do this, we have to maintain the focus on the best interests of the child. So while we understand that they come into conflict with the law, we have to maintain the rule of law, but consider the best interests of the child. So I'm going to share with you what currently obtains, so you can get an appreciation of what is taking place. So child diversion is what we call a 7-step program, and it is initiated once an offense is committed or the child is suspected of committing an offense. And the list is in the schedule, but I wanted to pull out, you know, some of them: noisy and disorderly conduct, damage to property, unlawful wounding, simple larceny and some of the larceny suite, as well as other offenses at the court's discretion. Those include the uncontrollable children, as well as some who are in need of care and protection. For the program to begin, the child has to accept responsibility. That's the first step, because we're rooted in restorative justice, and in order for us to restore the relationship, you have to be able to take accountability for your role. That's the first thing. Secondly, the victim has to give their consent to the matter being referred to child diversion. Again, we believe that justice has to be balanced, and we cannot dictate what redress looks like to a victim. So we cannot tell them that though this child committed this offense against you, it must be sent to child diversion without your consent. The Act does allow, though, if the victim is being unreasonable, that the court can consider sending the matter without it requiring their consent. I want to plug here, though, too, that the Social Justice Division, while we include restorative justice and child diversion, there's also the arm called Victim Services. The Victim Services branch focuses on victims of crime, and as such, once a matter is being referred to child diversion, we also recommend that the matter is referred for the victim to Victim Services. The referral is sent to us by the court or the police, as was stated before, and this is where it gets interesting. So once the matter comes to us, we do a thorough assessment of this child. So when they come to us, an initial intake assessment will take us about 2 hours, sometimes maybe even more, because we're asking a wide range of questions. We want to know from the child what is happening, from the parent what is happening, and we ask them questions. At one point, we ask the parent to leave the room. And at another point, we ask the child to leave the room, because there are times when the child might be doing something that the parent doesn't know about. Or the child might be presenting and saying, no, I'm not doing this, but the parent suspects that the child is doing that. So that is an important part of what we do. Once we do the intake assessment, and we have the tool that was developed in partnership with DCS to determine their risk level, we then determine the diversion options that can be provided for this child. I'm going to mention a few of them. So school attendance, this would mean whether you're enrolling or re-enrolling in school, vocational training, and we have psychotherapy for the individual and the family, sexual and reproductive health education, drug screening, treatment and counseling, mentorship, that is a big one, I know Minister touts a lot. And in the last 2 financial years, we have trained over 230 mentors, thanks to the, what do we call it? The media campaign that we've had, and Minister leading the charge in terms of us trying to recruit mentors. Yes, so we want mentors for the child diversion program because we believe that it is something that can help these young people. A lot of them have not seen positive influences outside of their communities and outside of their homes, and this is an opportunity that we get to do that as well.
And I just want to emphasize, I just want to emphasize, you see, that even the mentors who offer themselves, they go through strict tests, checks, because we don't want anyone in the body to be mentors. Indeed, to be frank with you, I try to encourage more JPs who have gone through the rigors. But to get anyone in the body, you don't know which pedophile will offer themselves. So we are very careful about who are the mentors. Right, sorry about that.
Thank you, Chair. So I wanted to clarify. So the interventions, the screening and so on, we have 14 parish offices. 11 of those are located at justice centers, where we share the center with the Restorative Justice Office, along with some of them the Office of the Customs. So, and we have some standalone offices that do the same thing as well. But we have 14 offices across the island. And as Minister mentioned, we ensure that we do vetting for our mentors and we train them, because we don't expect that you're going to come in as a, let's say, for example, a coach. You have the information about coaching, but do you have the information about adverse childhood experiences and how that will impact the behavior and so on? So we try to provide that information so they're well equipped. So when they come and experience a child exhibiting behavioral issues, they can then provide the requisite support that is required. So restitution is also another area that we use, and we use restorative justice a lot. I think you can, because child diversion is rooted in restorative justice. So from time to time, we will find that matters, before they're referred to child diversion, the court will utilize restorative justice, or they'll ask the child diversion branch to make the referral to restorative justice. So once the child successfully completes the program, the stipulated program, and I want to indicate too that the listed treatments, it can be one or a combination of a few of them. And because of this, the programs are individualized according to the risk factors that we identify for each child. As such, a program can last for 4 months, but it can also exceed a year. Because if we see that this child is in need of this intervention, we're not going to let you go back into the situation without addressing the issue, because that poses an issue in terms of reoffending as well. So if the child successfully completes the program, the matters related to that offense would be dismissed. Unfortunately, though, and I know Ms. Case will indicate in terms of some of the challenges that we face, we do have some matters that the children are not compliant, and we have to return the matters to the referral source. It's not what we want to do, but in the best interest of justice and in time and the resources of the government, we have to return these matters for the formal judicial proceedings to take place. So non-compliance will look like not coming to, not coming to the sessions. You have to be re-enrolled in school. You're not going to school. You have to try to pass a drug test. You cannot pass a drug test. You continue to show a form of substance in your system, those things, and I want to be careful about what we say here. So we don't just return a matter once we identify that. We work with the police and the court, and we try to get them to become compliant. So once we identify that this child is posing a challenge, we allow for a 6-month window to get this child back into formation. And if that doesn't work, we say to the court or the police, okay, you now have to re-intervene in this matter.
Sure.
I have a question. I just need some numbers so that I can get the context in my head right. How many children have you had under your program, and what percentage of that number completed the program?
We had it at the beginning.
I know, can you just give me? I wasn't here, I came late.
Yeah.
So just give me that number, please.
So we had 2,000, up to the end of January, we had 2,810. And we had 1,148 that completed the program. And you can understand, as Minister indicated, some are still in the program. Because of the nature of the program, it's not just a one size fits all. Or returned. I do not have that stats right here, but I do know that it is over 300 that we have returned because of non-compliance. And when I say non-compliance, if something happens and it's outside of the control of the child, we don't hold that against them. So say, for example, there's Hurricane Melissa, we can't contact you. And there's four months pass and we still can't contact you. We're not going to say, because we can't contact you then. We will try to reach out to the police to see if they can do a community visit. We'll indicate to the court what is happening, and you don't lose your intervention because of the time that elapsed. I don't want to say definitively only 300. I will confirm and let the committee know.
Just one question.
Sure.
And it is in relation, I've been listening for some information. If it's there, please guide me to it. But are there children who enter the system but are not referred to child diversion? That was a figure which was, not present in my mind. So I wasn't clear on how many children are actually before the court or have committed infractions but do not get the benefit of the child diversion program. And I thought that additional data would have been helpful.
I think, to be fair, we have to get that from the court statistician, because they would only know the cases coming to child diversion. But I will ask Dr. Dennis if...
I would really like it, because it will give me a full...
A broader picture.
A broader picture of what exactly is happening
because
with the
I
children.
don't, you wouldn't have that information.
And the reasons, it might even be good to have the reasons
why they don't
go into the program, so that we can strengthen the program.
Venetia, remind me to discuss with Dr. Dennis that broader number and just what percentage have been referred. Yes. Yeah. Okay, sorry, continue.
So basically that is the extent of my presentation. I will now turn, okay.
Sure, yes.
You mentioned briefly, Chairman, I wanted the qualifications for the mentors. You mentioned sometimes you use JPs, you use...
No,
I want a specific, what are the qualifications for these mentors? And have you ever had an issue with a mentor, somebody who went through your checks and balances, however, something happened and he or she is no longer a mentor?
So I'll answer the last question first. Not to my knowledge, as in somebody being trained and there's an issue. None has been brought to my attention, but if it is, then the committees in the parishes usually can make the decision in terms of if this person can continue as a mentor. The mentors, we usually ask for them to complete at least high school education. They must have 1 year work experience. They must be willing to volunteer for a year, and their vetting should not return any adverse findings. So what we do, we cannot select from particular backgrounds because the children, their interests might vary. So one child might be interested in robotics, another child might be interested in track and field, another child might be interested in business, so they're from a wide cross-section, but we try to ensure that they have the basic educational level to be able to give us reports, because we ask them for reports in terms of their engagement, what is happening, and we try to, out of an abundance of caution, though I know Minister normally talks about, the relationship being established and so on, we try to ensure in our trainings we ensure we tell them about what the do's and the don'ts of mentorship. So you don't cross that line. You're still a mentor and you're still mentoring a child.
What I should add to Member Smith is that it's a child diversion officer who is responsible for coordinating the relationship between the mentor and the child. So it is the child diversion officer who is in constant touch with that relationship, because the child diversion officer would choose a mentor that fits the behavior of the child, yes. And then you get almost a regular report coming from the mentor, because the child diversion, you see, and that is, we had to double up the number of child diversion officers, because one child diversion officer may well be supervising 20, 30 cases, and in some parishes it's more, so we have had to, I think we now have 19 child diversion officers, but we have
24 post chairman, but
and we only have 19.
19 currently.
And a number of these child diversion officers sometimes move on, migrate, so we are always in training more child diversion officers, but their basic assessment is to work with the mentor on the child, and also to assist in referring the child, if necessary, for psychological support, and to report back to the ministry how the program is going.
Child diversion managers, are they social workers?
So they're from they have social service background. So you have a wide array of social service professionals.
Okay.
So you know they come from the school settings and so on. And just for clarity, I want the minister, if you permit me, to just quickly mention the child diversion branch is supported by firstly, our principal director for the Social Justice Division, who has oversight for child diversion. The director of the child diversion branch. We have 24 officer posts. 19 of them have been filled. We're recruiting for the additional posts because you know the turnover sometimes. We also have 2 clinical psychologists who have been very helpful in terms of helping us to be able to provide the interventions, as well as contracting psychologists and other entities to be able to do the assessments and provide the interventions that are required.
Sorry? Go ahead.
I was just asking if you have any forensic psychologists on board.
Not practicing, they do have the training. So we do have members of our team who are trained as such, but in terms of practice, they're practicing as child diversion officers. Yes. So in order for us to be able to do this, in the last 2 years, we have over 100 million being spent on the child diversion processes, particularly for our partnership with the National Council on Drug Abuse, or psychologists that we have across the island. We have sessional psychologists that help us to provide the interventions for the children and the parents. We also do psychoeducational assessments, to determine what level this child is functioning at, and if there is need for additional intervention or additional sessions to be able to provide for this. So we are supported through the budgetary allocation to be able to do those things as well.
Thank you, Benicia. Sure.
So I had one little question. In terms of your caseload for each officer, what's the standard you're working with? And why are you smiling? What's the caseload?
We are, best practice would be at least 30 to 1, but currently I know, especially for our St. Catherine office, we're over 60 to 1 officer, and we have 2 officers in the office, Clarendon, St. James, the parishes, Kingston and St. Andrew, the ones that are, generally populated with more people, you have more cases being referred there.
Mm-hmm. There's no doubt that after these sessions, the likelihood is that if we widen the program, we may well need 3 or 4 officers in each parish, or at least some of the parishes. Mm-hmm. Finish?
Thank you, Minister. I will turn over to Ms. Case, who will now bring us through some of the, the concerns that we have in terms of the child diversion program once implementing on the ground.
Mr. Chairman, child diversion does far more than divert children from the formal justice system. It creates meaningful opportunities for rehabilitation, accountability, and transformation. Children and their parents are connected to essential services, as mentioned by my director: counseling, educational support, skills training, mentorship, and family interventions. These supports have significantly changed the trajectory of many lives. We have witnessed children once becoming repeat offenders return to school, gain employment, and re-engage positively with their communities. We have seen parents who felt overwhelmed, under-supported, access resources that strengthen the home environment through our parenting skills training sessions. The program recognizes that investing in the child also means investing in the family. One former participant shared his experience. After being charged at age 16 for assault, he was referred to the Child Diversion program. Through counseling and mentorship, he learned to manage his anger and make better choices. Today, he proudly serves in the Jamaica Defense Force, grateful for a second chance. Mr. Chairman, this is not an isolated story. It reflects many success stories unfolding across our parishes. By addressing harmful behaviors early and strengthening families, we are reducing reoffending, building safer communities, and shaping a more productive nation. However, Mr. Chairman, while the successes are significant, there are challenges at the parish level. Increasingly, children deemed uncontrollable are being referred to the program for behavioral issues that are not criminal offenses. This creates difficulty in applying the traditional accountability measures within the justice framework, while still providing meaningful intervention. Also, Mr. Chairman, a child having successfully completed the requirements of his child diversion program met all of the requirements for the JCF, only to be notified that there were adverse findings in his background check that he committed an offense. This occurrence contradicts the intent of the child diversion program. Despite this, Mr. Chairman, the child diversion officers continue to work closely with families, schools, and social services agencies to guide these children toward positive outcomes. Thank you.
Good. Right. Thank you very much. Yeah. I must admit, I hear these comments regularly from many child diversion officers. And one of the things which, I'm going to be asking every now and then a couple others from different parishes to come in and give us one or two other examples of stories. Mr. Levy, you gave us a very good one. Sorry.
I want you to allow my colleague beside me to say exactly what she turned around and just said, because I believe it ought to be.
Chairman, the other day a colleague minister of yours told me that I'm a hard marker, and I am. But I had to turn around and tell my colleague a while ago, I've never seen anything like this before. I'm really blown away by this team that has delivered this presentation today.
I want to thank, and I told you you're in for a treat because...
Yeah, I am, and I did not have the opportunity to read it before, but I will be reading before the next session so that I can have my questions ready for you, because this is what I've been praying for, that joint select committees would treated with. So I understand Mrs. Chevans and Mrs. Wigan. I see the two of them looking like they were proud mothers as they saw their team members delivering their presentation. But I want to say, and I really hope other teams are paying attention, because I have had occasion to sit in a joint select committee and have ministries or departments come, and I was embarrassed for them because they came ill-prepared. They came with a sense of laissez-faire. And this team has come here today, obviously prepared as a team, not just as individuals, but as a team. And they have delivered to us a very comprehensive document that I am going to do it the honor and respect of really combing through it as my colleague, Member Buchanan, has done. And I really thought it was important, Chair, and I'm sorry to take away from the substance of the committee, but this is not normal, and it has to be recognized.
No, and I want to thank you again on behalf of the draft. The person responsible, you haven't heard from her, but I had to interrogate her about it. And you could see the detailed examination of everything. And when you read it, you will be impressed. We want to wrap up. Mr. Levy, you said you had another. Yeah? Huh? You want to tell us of another example? Yes, and we wrap up with you.
Thank you, Mr. Chair, for the opportunity. I said, thank you, Mr. Chair, for the opportunity. I am almost becoming emotional, just listening to your stories and the response from the committee members. However, child diversion is not only reactive, although by nature it would seem that way, but there's a proactive element to child diversion, and I cite one example of a child that came to us. Bright boy, doing well in school, and involved in sexual intercourse with one of his peers at school. When they, pardon me? Yes, they were in an intimate relationship, right? And so when he came and we did the assessment, we realized that the sexual encounter was not his real issue, because his father was shot and killed. At age 12.
Oh no.
He started interacting with negative peers, and a range of layers of incidents that were affecting his life. And through, there were many criminogenic factors that came out as a result while doing the assessment. And through the intervention, the various interventions, we were able to address those needs. And so I don't want it to seem as if that committing a crime is positive. But hadn't that offense been committed and he come to child diversion, we would have seen it was a real criminal in the making. But we were able to capture, Mr. Chair and committee members, capture all of those things and put a
guidance and stuff.
Provide guidance. And he turned his life around. I mean, I wouldn't say 360 degree, but a 180 degree. It turns around. And so I believe that child diversion, in my opinion, is one of the best things that happened to children in Jamaica in this time.
Yeah, thank you, Mr. Levy. No, there are many, many more stories, and we'll give you some actual examples without trying to reveal too much, as you appreciate, because of the confidentiality of children, the background of children. But you can see, members, how important the program is. On Thursday at 10 o'clock, we have Jamaicans for Justice making their presentation. Again, I would invite you to read their report. They're critical, but also very supportive of the program. And I think it's useful to read it and then to do some questioning also during their presentation. But the team will also be here, and if there are underlying questions at the end of after the Jamaican for Justice presentation,